Today we'll talk about the United States court system, its structure, and the history of a specific United States Supreme Court case. First, you see the Supreme Court building of the United States in Washington, D.C., located on the left. On the right, Chief Justice Earl Warren, one of the very famous Chief Justices. He served from 1953 to 1969. First, we'll talk about state structure. In the United States, there's two separate court systems, the state system and the federal system. In the state system, there is limited or specific jurisdiction. Limited jurisdiction refers to your simple trial courts, things such as municipal courts, magistrate trial courts, or justice of the peace courts. Specific jurisdiction refers to more special cases, things such as juvenile crimes, probate or small claims courts, which are generally under $2,500 civil suits, and family law courts, which deal with things such as child custody, adoption, divorce battles, things such as that. The next level up in terms of criminal law is a district court. District courts usually cover a county or a conglomerate of counties and are the next step up from your simple municipal trial court. District courts usually deal with higher level crimes, things such as felonies. Both limited jurisdiction and specific jurisdiction can be appealed to the next court level, which is the appellate court level. State appellate courts typically do not preside over original jurisdiction, meaning that they don't hear the case on its first time. They must be appealed to that level. The next level up in the state structure from the appellate court is the state Supreme Court, which is the highest rule of law in the state. Similar to appellate courts, the state Supreme Court does not hear original jurisdiction cases either. The case must be appealed to that level. Separate from the state structure is the federal structure. The lowest level of the federal structure of courts is the district court. Every state has at least one district court, but more populous states have more. For example, the state of Michigan has two district courts, one in Grand Rapids and one in Detroit. The next level up from district courts are circuit courts, which include the appellate courts in the federal structure. Federal circuits are not located in every state. Generally, they're regional courts, which cover multiple states at a time. They all contain at least one district court and one federal court of appeal. From that level, the next level would be the United States Supreme Court, which is the highest legal authority in the land. A case may be appealed up from the district court level to a federal court of appeal, and from there up to the United States Supreme Court, or at times the Supreme Court hears cases that come through the state Supreme Courts. The Supreme Court presides over issues of constitutional matters, interstate legal battles, so battles between states, cases between United States citizens and foreign citizens, and cases involving conflict between state and federal law. They have the final say in terms of all legal issues in the country. State and federal appointments. Federal appointments are made in the district, circuit, and Supreme Courts by the President of the United States, and they do require U.S. Senate approval. On the left, you can see Chief Justice John Roberts of the United States Supreme Court. He was appointed in 2005 by President George Bush. Judges serving in special federal courts such as bankruptcy, tax, or military courts are appointed by Congress for 10-year terms. These 10-year terms are renewable, unlike Supreme Court terms, which are terms for life or until the Supreme Court justice decides to resign. State judges are appointed differently and by many different means. State judges can be appointed by the governor or the legislature. They may be selected by merit based on the State Bar Association and fellow judges, or they can be elected using partisan or nonpartisan elections. Partisan elections mean that the judge identifies with a certain political party, such as Republican or Democratic, and whereas nonpartisan elections, the judge does not affiliate themselves with any party on the ballot. The state of Michigan elects judges through a nonpartisan election, so you will not see any party affiliation next to their name. On the top right, that is Chief Justice Robert Young of the State of Michigan Supreme Court. There are many landmark cases that have passed through the Supreme Court that have helped the United States Supreme Court that have helped to define the law and the Constitution in this country. One of those cases is the state of Texas versus Gregory Lee Johnson in 1989. Mr. Johnson was known for burning a flag at the 1984 Republican National Convention in Texas, where he was arrested for desecration of a venerated object, because at that time in 48 of the 50 states it was illegal to burn the United States flag. He was then convicted on that charge and sentenced to 1 year in prison with a $2,000 fine. Mr. Johnson appealed that decision to the State Court of Appeals of Texas, where he lost his case. He then further appealed that to the Texas Court of Criminal Appeals, which is the highest court of appeals in Texas. He there won his case based on the court's decision that his burning of a flag was covered under the freedoms of speech in the First Amendment of the Constitution. The state of Texas did not accept this decision by the court, and they asked the United States Supreme Court to hear the case. The Supreme Court decided by a 5-4 vote in favor of Mr. Johnson, with the majority opinion was written by Justice William Brennan, who is located on the top left there. The Supreme Court ruled that the burning of the flag was an expressive conduct. It was conduct of speech and was therefore protected by the First Amendment freedom of speech. For more information on the Texas versus Johnson case, you can check out the link at the bottom there, as well as a simple Google search will give a lot more background on the case.